Okay, in Colorado versus Bertine, Chief Justice Rehnquist delivered the opinion in the court in 1987. A Boulder, Colorado police officer arrested a respondent for driving his van under the influence of alcohol. After a respondent was taken into custody and before a tow truck arrived to take the van to an impoundment lot, another officer acting in accordance with local police procedures, inventoried the van's contents, opening a closed backpack in which he found various containers holding controlled substances, cocaine paraphernalia, and a large amount of cash. Prior to his trial on charges including drug offenses, the state court granted respondent's motion to suppress the evidence found during the inventory search. Although the court determined that the search did not violate respondent's rights after the Fourth Amendment of the federal Constitution, it held that the search violated the Colorado Constitution. The Colorado Supreme Court affirmed, but premised its ruling on the federal Constitution. We grant certiorari to consider the important and recurring question of federal law, deciding by the Colorado Supreme Court, as the court recognized inventory searches are now a well-defined exception to the warrant requirements of the Fourth Amendment. The policies behind the warrant requirement are not implicated in an inventory search, nor is the related concept of probable cause. Quoting, the standard probable cause is peculiarly related to criminal investigations, not routine non-criminal procedures. The probable cause approach is helpful when analysis centers upon the reasonableness of routine administrative caretaking functions, especially when no claim is made that the protective procedures are a subterfuge for criminal investigations. For these reasons, the Colorado Supreme Court's reliance on Arkansas v. Sanders Supra and the United States v. Chadwick Supra was incorrect. Both of these cases concern searches solely for the purpose of investigating criminal conduct, with the validity of the searches therefore dependent on the application of the probable cause and warrant requirements of the Fourth Amendment. By contrast, the inventory search may be reasonable under the Fourth Amendment, even though it is not conducted pursuant to warrant based on probable cause. By contrast, an inventory search may be reasonable under the Fourth Amendment, even though it is not conducted pursuant to warrant based upon probable cause. In South Dakota v. Opperman, 1978, this court assessed by reasonableness an inventory of search of the glove compartment in an abandoned automobile impounded by the police. We found that inventory procedures serve to protect an owner's property while it is in the custody of the police, and to ensure against claims of lost, stolen, or vandalized property. And to guard the police from danger, period. In light of these strong governmental interests and the diminished expectation of privacy in the automobile, we upheld the search. In reaching this decision, we observed that our cases accorded deference to police caretaking procedures designed to secure and protect vehicles and their contents within police custody. In our more recent decision, Illinois v. Lafayette, 1983, a police officer conducted an inventory search of the contents of a shoulder bag in the possession of an individual being taken into custody. In decision whether this search was reasonable, we recognize that the search served legitimate governmental interests similar to those identified in Opperman. We determined that those interests outweighed the individual's Fourth Amendment interests and upheld the search. In the present case, as in Opperman and Lafayette, there was no showing that the police who were following standardized procedures acted in bad faith or in the sole purpose of investigation. And in addition, the governmental interests justifying the inventory in Obermann and Lafayette are nearly the same as those which taken here. Which obtain here. In each case, the police were potentially responsible for the property taken into their custody. By securing the property, the police protected the property from unauthorized interference. Knowledge of the precise nature of the property helped guard against claims of theft, vandalism, or negligence. Such knowledge also helped to avert any danger to police officers or others that may have been posed by the property. The Supreme Court of Colorado opined that Lafayette was not controlling here because there was no danger of introducing contraband or weapons into a jail facility. Our opinion in Lafayette, however, did not suggest that the station house setting of the inventory search was critical to holding in that case. Both in the present case and in Lafayette, the general governmental interests described above were served by the inventory searches. The Supreme Court of Colorado also expressed the view that the search in this case was unreasonable because Bertine's van was towed to a secure, lightweight facility. Because Bertrand himself could have been afforded the opportunity to make other arrangements for the safekeeping of his property. But the security of the storage facility does not completely eliminate the need for inventorying. The capital may still wish to. The police may still wish to protect themselves or the owners of the lot against false claims of theft or dangerous instrumentalities. And while giving Bertine an opportunity to make alternate arrangements, which undoubtedly would have proceeded, we said in Lafayette, the fair question is not what could have been achieved, but whether the Fourth Amendment requires such steps. The reasonableness of any particular governmental activity does not necessarily or invariably turn on the exercise of alternative, less intrusive means. We conclude that here, as in Lafayette, reasonable price regulations relating to inventory procedures administered in good faith safely or satisfy the Fourth Amendment, even though courts might, as a matter of hindsight, be able to devise equally reasonable rules requiring a different procedure. The Supreme Court of Colorado also thought it necessary to require that police, before inventorying a container, weigh the strength of the individual's privacy interest in the container against the possibility that the container might serve as a repository for dangerous or valuable items. We think that such a requirement is contrary to our decisions of Obermann versus Lafayette. Quoting, even if less intrusive means existed, protecting some particular types of overlay of property, it would be unreasonable to expect police officers in the everyday course of business to make fine and subtle distinctions in which, as a result, Lafayette Bertrand finally argues that the inventory search of his van was unconstitutional because the department regulations gave the police officers discretion to choose between impounding his van and parking and locking it in a public parking place. Supreme Court of Colorado did not reply on his argument in reaching its conclusion, and we rejected it. Nothing in Operman v. Lafayette prohibits the exercise of police discretion as long as the discretion is exercised according to standard criteria on the basis of something other than suspicion of evidence of criminal history. Here, the discretion afforded by Boulder police was exercised in light of standardized criteria. Related to the feasibility and appropriateness of parking and locking the vehicle rather than impounding it. There was no showing that the police chose to impound Bertine's van in order to investigate suspected criminal activity. The judgment of the Supreme Court of Colorado is therefore reversed. So I have time to go into the dissenting opinion, if I can help it. One of the notes here is just expanding on the omitted part of the case. One of the footnotes here is Florida v. Wells, 1990, where all members of a court agreed that the inventory of a locked suitcase found in an impounded vehicle was unlawful under Bertine because the FHP had no policy with respect to the opening of closed containers encountered during an inventory search. 5 members of the court went on to say that the state court erred in saying Bertine requires a policy either mandating or barring inventory of all containers. A police officer may be allowed sufficient latitude to determine whether a particular container should or should not be opened in light of the nature of the search and characteristics of the container itself. Thus, while policies of opening all containers and opening no containers are unquestionably permissible, it would be equally permissible to... Okay, anyhow, I'm just going to read the... It looks like a concurring opinion. I join from Blackman, Powell, and O'Connor. I join the court's opinion, but write separately to underscore the importance of having such inventories conducted only pursuant to standardized police procedures and mandate the opening of a Justice Marshall, Brennan joined dissenting. The record indicates that no standardized criteria limited Boulder police officers' names, recording. I think I'm going to have to read this another time. No, I'm going to have to get through this. All right, we got a dissenting opinion here. The record indicates that no standardized criteria limit a Boulder police officer's discretion. According to the departmental directive, after placing a driver under arrest, an officer has 3 options for disposing of the vehicle. First, he can allow a third party to take custody. Second, the officer or the driver, depending on the nature of the arrest, may take the car to the nearest public parking facility, lock it, and take the keys. Finally, the officer can do what was done in this case, impound the vehicle and search the inventory, its contents, including closed containers. Under the first option, the police have no occasion to search the automobile. Under the park and lot option, closed containers that give no indication of containing either valuables or a weapon may not be opened, and the content search, if i.e. inventoried, emphasis added. Only if the police show a third option are they entitled to search closed containers in the vehicle. Where the vehicle is not itself evidence of a crime, as in this case, the police apparently have totally unbridled constitution discretion as to which procedure to use. Consistent with the conclusion, Officer Ryanbach testified that such decisions were left to the discretion of the officer on the scene. Once a Boulder police officer has made the initial arrest, I feel like that's not what this says. It says, once a Boulder police officer made his initial complimentary discretionary. Oh my God. Once a police officer has made this initial completely discretionary decision to impound a vehicle, he is given little guidance on which ways to search and what sort of items to inventory. An arresting officer, Toporek, testified at a suppression hearing as to what items would be identified. That would, I think, be very individualistic as far as what an officer may or may not go into. I think whatever arouses his suspicions as far as what may be contained in any type of article in the car. Inventory searches are not subject to the warrant requirement because they are conducted by the government as part of community caretaking function. Totally divorced from the detention, investigation, acquisition of evidence relating to the violation of the criminal statutes. Standardized procedures are necessary to I lost my spot. Ensure that this narrow exception is not improperly used to justify, after the fact, a warrantless investigative foray. Accordingly, to invalidate a search that is conducted without established procedures, it is not necessary to establish that the police actually act in bad faith or that the inventory was in fact pretext by allowing the police unfettered discretion. Beliefs. Not only are the government's interests weaker here than in Operman and Lafayette, the respondent's privacy interest is greater. The upholding of the search in Operman, the court emphasized the fact that the defendant had a diminished expectation of privacy in his automobile due to pervasive and continuing governmental regulation and controls, including periodic inspection and licensing requirements, and the obvious public nature of automobile travel. Similarly, in Lafayette, the court emphasized the fact that the defendant was in custody at the time the inventory took place. Here, the court completely ignores respondent's expectation of privacy in his backpack. Whatever his expectation of privacy is in his automobile generally, or our prior decisions clearly established that he retained a reasonable expectation of privacy in the backpack and its contents. See Sanders, luggage is a common repository for one's personal effects, and therefore inevitably associated with the expectation of privacy. Chadwick, a person's expectation of personal privacy and personal luggage, and are indeed the police office. Okay. A person's expectation of privacy and personal luggage are substantially greater than in an automobile. Indeed, the Boulder police officer who conduct an inventory acknowledge that backpacks commonly serve as repositories for personal effects. Thus, even if the governmental effects of this case will be the same as those greater expectation and privacy in his luggage. same as those in Obermann, they would nonetheless be outweighed by respondents' comparatively greater expectation of privacy and its luggage. I'm going to edit there.